So I will be talking about Scotland, but mainly as a case study of sort of broader themes around the use of the term rights and sort of rights discourses with respect to addressing homelessness. The reason for, I've been asked to talk about Scotland, and I will talk about Scotland, but myself and colleagues at Cardiff University, Peter Mackey and others, have been doing some work for the Welsh Government, as many of you will know, with respect to a review of the Welsh homelessness legislation. So some of you have already heard me say quite a bit about Scotland already, so I thought I'd perhaps widen the discussion for those of you that have already been to quite recent stakeholder events, which myself, Pete and others have been running in Wales. Why do we talk about rights in terms of in homelessness, and why is it such a sort of central part of the debate? There's a great demand for rights-based approaches in tackling homelessness. You can see this demand across Europe. The European Federation of Organisations that Work with the Homeless, FIANSA, has been demanding a rights-based approach to addressing homelessness for some time. There are also demands for rights-based approaches in other developed countries. Housing rights groups in the United States, Australia and elsewhere make frequent demands for a rights-based approach to tackling homelessness and housing need. And rights-based approaches are kind of intuitively appealing. They seem radical, they seem straightforward solutions to complex needs. They offer the possibility for empowering disempowered groups and overcoming stigma, the stigma particularly associated with more discretionary forms of welfare assistance. But what I'd like to focus on tonight, or get us to think about tonight, is when we ask about, or we make demands to adopt right-based approaches, what do we actually mean by rights-based approaches? And do they actually deliver the things we expect them to in practice with respect to homelessness and housing need? As I said, I will be talking about Scotland, and Scotland is a good example to talk about in an occasion like this, because it has an exceptionally strong focus on legal rights and addressing homelessness. I would say the strongest anywhere, actually, certainly anywhere in Europe, and I'm pretty sure anywhere in the developed world. But does it provide a model for elsewhere? Is it the ideal model that it's sometimes, I think, held out to be? To pick up this issue about the meaning of rights, first of all, I mean, where this particular sort of line of argument came from, as I have to confess, I started to get a little irritated when I was reading a lot of the debates around rights and homelessness, because I felt that academics, pressure groups and others tended to conflate several different things when they talk about rights, which are actually really, in concept, quite different. And have different meanings and also different implications with respect to policy. So rights can be moral, they're things you ought to have, or they can be legal, that you do have an entitlement to something. These things are often conflated, whether we're talking about somebody having a right to something or that they ought to have a right to something. Rights can be abstract or specific. They can be abstract rights like the right to privacy or the right to a family life, or they can be very specific rights, the specific rights people have to income support in certain circumstances in the UK. These are both rights, but they're of a very different order. And very importantly, rights can be operational at national level. They can be within domestic legislation or within domestic debates, or they can be international. And picking up that final distinction, how I'd like to organise my talk tonight is by starting off by saying a little about rights with respect to housing and homelessness in the global realm, rights which are seen to be universal or at least international, and also then go on to talk about rights, the rights-based discourse and frameworks at national level. And there are some further distinctions I'll pick up when I do so. First of all, rights in the global realm. I'm going to start sort of bit broad and philosophical and abstract. I will honestly get a bit more practical and focused as I move on. There is a sort of moral impetus that underlies, I think, a lot of the rights debates, not just in housing and homelessness, but more broadly, which can find its roots in what is often called the natural law tradition. It's got very deep roots. It goes back to the Enlightenment. And in this liberal tradition, which is associated with individual rights, there is this concept that people have universal, inalienable rights just by virtue of the fact that they are a human being. These rights are sometimes thought of as being bestowed by God or some other theological source, or intrinsic to the fundamental nature of humanity. In the I've got a legal background many years ago, so within the sort of jurisprudential world, jurisprudential debates, this would be seen as associated with the natural law tradition, the idea that what naturally is ought to be in law. Now, there's a lot can be said about the natural law and the natural rights tradition, which isn't something I want to say a lot about tonight. But the reason why I mention it is because in some ways the human rights debate, which is obviously very important nowadays, can be seen as the modern successor, the modern cousin of the natural the natural rights agenda. Of course, human rights tend to find their expression in international instruments of various kinds. We have a number in Europe which are relevant. The International Covenant on Economic, Social and Cultural Rights is relevant, of course, at a global level. Some countries have ratified it, others haven't. But it's very relevant to housing and other social rights. And also within Europe, we have the European Social Charter, which makes specific mention of rights to housing. So we have these broad international global instruments, international instruments, which are binding in international law, often on ratifying countries. Not all countries ratify, but many do. The key thing about both natural rights and human rights is they are of a kind of moral order. They're essentially moral statements about what we think human beings ought to have a right to. They ought to have access to these rights, including, where relevant, the right to housing. And for many people, this is the kind of the basis on which they would develop arguments around homeless people's rights to housing. Now, in a sense, you might argue, well, surely certainly everybody who's of a progressive political bent surely has to be in favour of a right to housing for people who lack it. How could you feel otherwise? Well, I think because that tends to be the sort of instinctive reaction of people, I want to be perhaps a little controversial by emphasising more what the limitations or what the critiques might be of a human rights approach to homelessness, partly because it has become quite dominant, particularly in international debates. There's two sets of criticisms I'd like to run past you. One is more sort of philosophical and foundational, which is summarised in this first overhead, and the other one is more pragmatic and more practical. First thing is, and most fundamentally, is intrinsic to this notion of human rights is the idea that they're self-evident, sometimes that's stated, they're inalienable and they're non-negotiable. In other words, they're absolute. But I think the question for me is, are the rights which are, particularly social rights, rights to resources, which are written in by the architects of human rights instruments, that are written into these instruments, any less politically contested than other sorts of claims to resources? If one dispenses with a theological foundation for rights, and I for one certainly do, then what is the basis of what is their foundation? What's the basis of their protected status, I think, is an important philosophical question. Now, some people would argue there is a foundation, a socially constructed foundation, in something of a global normative consensus on what people have to have access to in order to live a decent standard of living. I think there's a lot of debate on that, and one could say at the very least it's arguable whether there is such a global consensus. Another line of argument, which I personally find a bit more convincing, tries to find a more objective foundation for international human rights. In core human capabilities, needs and frailties, there's things that we all share on an objective basis, things that we all need access to live a flourishing life. And it appeals to the sort of common sense notion that those things that you need, you ought to have a right to. Again, as I say, in some ways I find that quite a sort of persuasive argument. But it also has its limitations. There are many things which human beings, at least arguably, need. We need love, we need respect, we need dignity, we need belonging, social relationships, and we can't give people those in a formal framework of rights. So the idea of any kind of easy equation between, or absolute equation between needs and rights, I think is arguable. But I think there's also a more practical set of considerations with respect to the use of a sort of human rights approach not just with respect to housing and homelessness, but certainly is very relevant to housing and homelessness. Goes back to the point I made at the beginning that rights can be very specific or they can be very broad and abstract. And one of the issues for me with a human rights-based approach to tackling social issues like housing need and homelessness is that almost by definition human rights instruments have to be broad and abstract rather than specific and delimited. What that means, when you think it through, is that if courts are having to enforce these rights, and obviously often courts don't enforce human rights instruments, but where they do, then it does imply a transfer of policy-making power from the political sphere to the legal sphere. And so with respect to housing and homelessness, what you have is judges, unelected judges, making decisions about the allocation of scarce resources. Now, that might be something that people for various reasons are in favour of, but I think in a democratic society it should at least give you pause for thought. That's rights at the global realm, and those kind of discourses about human rights in particular are becoming more and more prominent in debates around homelessness. So that's why I wanted to say something about them to frame the discussion tonight. But for many practical purposes, the most important sets of rights are the ones, and the debates and the actual rights as implemented are within the national realm. And of course, there's a very long history of citizenship rights, certainly in many European countries, and including in the UK. There's of course civil and political citizenship rights, which many people in this room will have studied if they've done politics and allied subjects. But of course, what I'm interested in tonight is social rights, specifically substantive entitlements to goods and services such as housing. Now, at the level of the nation state or at national level, there is an important distinction to be drawn, I think, between what you can use different phrases, and different authors do use different terminology, but terminology I've used here is between programmatic rights and legal rights. Programmatic rights are where there is a right asserted to something, such as housing, but it's unenforceable at the behest of individual or individual households in the courts. Now, this is actually by far the most common kind of right to housing there is. Constitutions all over Europe have a right to housing and beyond. Many countries in the developing world as well have a right to housing enshrined in their constitution. It's very, very common. But these are almost never enforceable in the courts at the behest of individual households. They're more, I think, appropriately seen as aspirational, or as a colleague of mine and David's and several other people, Bo Bengtsson from Sweden, calls them political markers of concern. I think that's a nice way of putting it. They sort of flag up that this is something that the government and institutions of that country ought to try and promote as a collective duty, the provision of, but it doesn't give any individual person or household an entitlement to anything that the courts will enforce, were they to find themselves without it. That's the most common kind of rights you find, certainly in the housing field, and very often they're in constitutional provisions. What we are very unusual in the UK is actually having legal rights, by which I mean sometimes they're called legalistic rights. That's the terminology that Bo Bengtsson, professor in Sweden, uses. But legal rights is a sort of shorthand I'm using for rights which a court will enforce. So if you do not have your entitlement satisfied by the relevant authority, then a court or some other judicial body, like a tribunal, will intervene and will enforce your entitlement. Now, what we find in terms of legal rights in homelessness, and I've done a lot of recent work comparing both the law and policies on homelessness in a range of different countries. I mean, most recently, as part of this work that we're assisting with for the Welsh Government on the Welsh homelessness legislation, but also over a number of years for other funders. So we've looked at a great number actually of European countries, but also other developed countries, English-speaking countries, the United States, Australia, New Zealand, Canada, and so on. And what we've found is that enforceable rights to housing are very unusual for homeless people. And I want to draw a distinction here between rights to housing and housing rights. Housing rights, in other words, rights to be protected from unlawful eviction or harassment and so on. Those, of course, are found in most countries, regulating the relationship between landlord and tenant. When I'm talking about enforceable legal rights here, I'm talking about a right to housing for people who lack housing. That is very unusual. And where it does exist, it almost always is limited to emergency shelter. You have a right to a roof of some kind rather than a right to permanent or settled housing. So there are a number of examples in Europe and elsewhere where there is some sort of entitlement to emergency shelter. These entitlements are usually founded on legislation such as police laws. The police have a responsibility to make sure there is no one sleeping rough in their local area. Or sometimes in social welfare laws, that the local social welfare authorities have a duty to ensure that that no one is in severe distress in their area, and that would include, has been interpreted to include people sleeping rough. Excuse me. So you have these entitlements to emergency shelter, which are in some cases viewed as clear and specific enough that a court will enforce them. So a number of countries have these. Germany, for example, has it under police laws. Sweden has it under social welfare provision. Perhaps some surprising countries, Poland and Hungary, have similar kind of rules where it's actually the social welfare authorities in those countries which have responsibility to offer some kind of roof. And very often this would be in a hostel or night shelter or something of that kind. New York City, I believe, as well in the United States, I think alone of all the only one in the United States, similarly has a right to shelter for people who are literally roofless with nowhere else to go. So insofar as there are enforceable rights that a court will actually intervene to ensure that people have access to, it's usually limited to those. Enforceable rights to settled housing, to permanent, or UK government prefers us to talk about settled housing, but to long-term housing are limited to only 2 countries as far as I can work out, and I'm fairly sure I'm right on this, would be the UK and France. Now, the UK, clearly, I know a number of people are really quite expert on what the position is in the UK, but not everyone, so I'll say a bit more about that in a moment. On France, the French position is very interesting, and actually it's very recent. Since 2008, there was a very vociferous media campaign run in France in the winter of 2007-8, which led to some emergency legislation in early 2008 in France, legislated for a right to housing for homeless people and others in severe housing need in France, and actually, at least in terms of the debates, modelled itself to some extent on the Scottish model, although what they've actually legislated is very, very different from the Scottish model, but there was inspiration drawn from Scotland to some extent. It's very complicated, the position in France, but to summarise it briefly, the position is if you have waited an abnormally long time to be allocated social housing, then a local administrative tribunal will fine the local state until such time as they provide you with housing. But the extent to which it has been implemented has been investigated, and so far the actual practical implementation, the number of people who have gained housing as a result of it, is really very small so far, partly because of the administrative complications in France. But looking at the UK, where we've got this much more long-standing system, as I say, I'm telling many people in this room things they already know. For those of you who are not familiar with this area, since 1977, there's been legislation in the UK, came into force in 1978, whereby local authorities must ensure that accommodation is made available to unintentionally homeless households in priority need. So if you're a household that finds yourself homeless, and homelessness is defined quite broadly. You don't have to be on the streets, but you have to have no secure housing that you're entitled to live in together with your family. If you find yourself in that position through no fault of your own, then and you're also in a priority need group, then the relevant local authority has a duty to ensure that settled long-term housing is made available to you. Now, the priority need criterion has been very, very important in all of this because it's been the main rationing device. To come into the priority need criterion, you have generally had to be a family with dependent children, or else a vulnerable adult with demonstrable support needs of various kinds, particularly to do with health or old age and so on. The key thing, you might have heard that Scotland's got this new model for Scotland's going to end homelessness at the end of 2012, and the Scottish model is terribly progressive, and it's won these international plaudits, as I alluded to earlier in my speech. In a sense, the Scottish target is rather more prosaic than that makes it sound, because what Scotland has undertaken to do is simply this: to abolish the priority need criterion by the end of 2012. So what that means is, by the end of 2012, everyone who is unintentionally homeless in Scotland will be entitled to settled housing, regardless of priority need. Now, that's been the legislation which supported that aim was passed in 2003, and priority need has been gradually phased out over that period. So actually, most Scottish local authorities are almost there. They're finding over 90% of people who apply to them as being in priority need, but there's that final push, and bigger in some authorities than in others this year. So in one sense it's more prosaic than ending homelessness, but on another level it is actually very ambitious, because it brings a lot more people into the statutory homelessness system, particularly single men, and also as a statement of principle to say that everybody in Scotland who is homeless through no fault of their own will be entitled to settled housing, secured by the local authority, not necessarily social housing, but usually it will be, is quite an important statement of principle as well. And Scotland really stands out from all other countries as being having a far stronger emphasis on legal rights as a means of addressing homelessness than anywhere else in the UK, at least at the moment, and certainly as compared with any other countries. Now again, Scotland has been, has gained a lot of praise. There's been a lot of attention in France. The Scottish model was used a lot in parliamentary debates and elsewhere. There's been papers written about it by Australian, American, and other academics. We want the Scottish model here, and so on. And I'll say a bit more just before I end about the Scottish, the practical experiences in Scotland and how we've got on with all of that. But I want to say something before I do so about the advantages and disadvantages of legal rights a bit more broadly, because I think these are, we can see the evidence of these in the Scottish model, because if you like, it's the sort of apogee of that kind of legalistic approach to tackling an issue like homelessness. I mean, in many spheres of welfare, there is a strong, and I have to say I share this, a strong sort of intuitive pull towards rights-based approaches as an alternative to what some people have called the more odious forms of official discretion. The idea that somebody, a service provider, an official you're dealing with, has that sort of power over you because they have discretion over whether you have access to something or not. It just seems far more appropriate, far more civilised for people to have an entitlement than for someone to have that power over them. So this idea that it empowers claimants, it helps to correct or to counter to some extent that power imbalance between the service provider and the service user by giving them a right of action if their needs are not satisfied. It has been argued that rights-based approaches reduce stigma because you receive something not as a matter of charity but as a matter of entitlement, which reflects your equal status as a citizen rather than your unequal status as a beneficiary, where there's a sort of implied notion of gratitude because there's no reciprocity there. You're being given something, it's sort of alms to the poor and you ought to be grateful. The idea is that rights-based approaches overcome that. And this final point, I think, is very important. It promotes the meeting of need, because when service providers, officials, local government, and so on have to make decisions about how they distribute resources, one of the arguments for having rights-based approaches is if you attach those rights to the people in the greatest need, then it will help ensure, or certainly help encourage, distribution based on need and meeting the needs of those who are in the most desperate situations. Now, I think this is a particularly important point with respect to housing, because there's quite good evidence on this point, international comparative evidence. As I've said earlier, because in most countries outside of the UK and more recently France, there tend not to be enforceable rights to housing for any group, and certainly not for homeless people. What we find is that social housing providers in most European countries, and that includes countries that are normally seen as progressive, such as Sweden, Finland, the other Scandinavian countries, but France, Germany and so on, social housing providers routinely exclude the poorest and most vulnerable from social housing in a context where they are not under a legal duty to house those households. So I think there's evidence that that's an important point, particularly with respect to housing rights. But there are some very important disadvantages of legal rights, and sometimes, well, actually most of the time, I would say these are rather skated over by the advocates of rights. There can be what is sometimes called a pathology of legalism when social welfare, social provision is based on very detailed statutory provisions where people can basically sue if they don't get access to something. Then the idea is you become very risk averse, you become the power and resources become concentrated in the hands of lawyers, and organisations spend their whole time what they call judicially review-proofing themselves rather than getting on with their job, which is to solve the problems of the people who are using their services. It can frustrate the fundamental purpose that the social welfare legislation was set up to achieve. And very strongly linked with this, and I think very important in the homelessness context, is the idea that it can lead to a more adversarial, process-orientated form of interaction with service users. So rather than looking at what's this person's problem and how do I best resolve it, how do I most creatively engage with this problem, you work out who's in, who's out, who's entitled, who's not entitled, and most importantly, because you're under legal pressure, you work out how do I evidence my decision in such a way that I cannot be legally challenged. So the resources and the focus can end up there. There's an issue about perverse incentives, which in the housing context it runs like this. If you give homeless people an entitlement which gives them some priority in the allocation of social housing, you shouldn't be surprised if people try to have themselves categorised as homeless in order to get that social housing priority. And finally, and I think possibly paradoxically, you could argue that legalistic rights, far from undermining stigma, can actually reinforce it. And that's because almost inevitably legalistic rights have to be selective. You can't have a situation, in most cases you have limited resources, so you have to define quite closely who is entitled to them. And if the criteria you're using is based on things such as need, poverty, homelessness, and you're attaching a stigmatised category to people in order for them to access something, and so there is an argument that that can actually increase stigma rather than reduce it. So the experience in Scotland, where we've probably gone, as I say, further than anyone else in trying to use a rights-based framework to address homelessness. What's the evidence with respect to these pros and cons? Now, I have to say the evidence in Scotland is not complete. There's not been a sort of fundamental evaluation of the programme in Scotland. What we have is bits of evidence about what its outcomes are, what its implications are, what the resource issues are, how people feel about it. But there's not really been a sort of an independent, thorough evaluation that asks the sort of deeper questions which I'm posing tonight. In fact, myself and colleagues have just asked for some money to do such an evaluation, so perhaps it will be available in the future, but it isn't as yet. But we do have some evidence to go on. I mean, and some of this is as a matter of logic. I mean, Scotland's strengthened, or maybe more accurately, broadened safety net extends protection to single people, particularly single men, but also single women, just in terms of sheer numbers. Single men are more important, but also single women. And there is evidence that one important outcome of that is that the high needs group, the people who've got more complex issues well beyond housing, which tends to be concentrated among single men, they're getting a lot more help than they did before, and it means the system is staying in touch with that high needs group, which didn't happen before. So things like repeat homelessness are falling, we think, at least in part, because there is a duty to provide some sort of long-term support to that group. And, as a matter of logic, clearly if you've got a group of people who are homeless and there's an entitlement to resolve at least some of those people's issues, then it's difficult to argue that that's not a progressive policy to have. But there is definitely a downside. The use of temporary accommodation in Scotland has grown significantly. And this is because in most cases when people are accepted as having a statutory right to be rehoused under the statutory homelessness legislation, there is seldom a house to put those people in immediately. Usually people have to spend some amount of time in temporary accommodation while they await rehousing. And because the statutory demand through the statutory system has increased so much since the extension of priority needs started, it means that the use of temporary accommodation has grown significantly. So to put some numbers on that, in March 2001, at the end, these are snapshot figures on a single night. At the end of March 2001, there were around 4,000 households in temporary accommodation. By March 2011, that had risen to 11,000 households, so it's trebled in that time period. And I think in some ways even more concerningly, the proportion of social housing lettings absorbed by statutory homeless households has risen quite significantly, from about a quarter to now 55% and growing. It's moving towards 60% and is well over that in some local authority areas. Clearly that's a concern because there's other people in housing need who need access to social housing in Scotland, but also because of the perverse incentives issue. Clearly if the only feasible route into social housing in some areas is a statutory route, then it doesn't sharpen those incentives to have yourself found to be homeless. So there's a lot of concern. Clearly this has focused the mind in Scotland in terms of how do we reduce statutory demand, and also how do we improve outcomes, because the statutory homeless route and a social letting, a social tenancy, is not always the best outcome for everyone, particularly for young people. And a large proportion of statutory homeless households are young people under 25, young single people under 25. So I think what Scotland is now looking to do, and particularly in the last couple of years when it's became clear that to meet the 2012 target, we weren't going to be able to build our way to it. The supply of new social housing was never going to be enough to try to reverse those figures in terms of temporary accommodation use and access and the proportion of social lets going to statutory homeless households. We had to find another way to control statutory demand. There's been far more emphasis on prevention approaches, and particularly picking up what has been a more vigorous approach to prevention in England, I think actually to some extent in Wales as well. Excuse me. Whereby when people approach a local authority for help, rather than simply being assessed for their entitlement under the statutory system, the whole range of possible ways of resolving their problems are investigated. Excuse me. That's only really kicked in the last couple of years, but we're already beginning to see some very hopeful signs, I think, that those local authorities in Scotland which have done the most on homelessness prevention are beginning to see their statutory numbers come down in terms of acceptances and also the numbers in temporary accommodation. I've said there about the important role of the Scottish housing regulator, which I think is very important in the Welsh context, where there's much less inspection and regulation of social housing, I understand, than there is in Scotland. The Scottish housing regulator is very, very careful with social housing providers to ensure that they do not gatekeep, that when people come to them for help with homelessness, then they are given their statutory rights. So when the housing options approach was first mooted in Scotland, social housing providers needed a lot of reassurance from the Scottish housing regulator that they would not be given a hard time for discussing people's options rather than simply putting them through the statutory route. The Scottish housing regulator has come out now very strongly in favour of the housing options route, and has tried to support the Scottish Government and local authorities in pursuing a more vigorous approach to homelessness prevention. So Scotland's trying to square that circle, have the strong statutory safety net, but at the same time trying to prevent as many people as possible from having to go down that route in the first place. It's still early days, but there is some promising signs, I think, that we're going to be able to manage to square that circle. So, to conclude, excuse me. In terms of the sort of broader points I started off with, where I tried to get people, and so made the assumption that many people would be sympathetic to human rights in the audience, so tried to put the counter case, if you like, is the kind of main point I want to get across is that it's perfectly possible logically to be sympathetic to the kind of moral discourse of universal moral rights or human rights, but sceptical about enforceable legal rights. You might think enforceable legal rights are too legalistic, they're too atomistic, they're counter to problem-solving approaches and so on, but still have a general commitment to a sort of human rights ethos and way of looking at the world. Conversely, and I think this might be probably closer to my own position, it's possible to be rather sceptical about human rights as a kind of progressive, as the main normative paradigm. I'm rather more sympathetic to social justice than human rights as a paradigm, but actually think that enforceable legal rights are likely to be effective, at least given certain circumstances and for certain groups, and so on. So sympathy with one doesn't necessarily imply sympathy with the other, hence my irritation at the notion of a rights-based approach in a general sense. I need to know what kind of rights-based approach you're talking about. You're talking about enforceable legal rights, you're talking about broad abstract rights that give courts a lot of power. And for me it depends which you're talking about, how likely I am to be sympathetic. The other sort of fundamental point, I think, is the need to maintain a critical perspective on all rights discourses. I think one of the concerns I have about rights arguments is that because of their sort of notion of them being absolute, they can tend to operate to close down debate. Once somebody's invoked a right, then there's nothing more to be said. And I think it's very important to maintain a critical perspective on rights as we do on any other kind of normative framework. I've made the point about abstract rights, much as they can seem very attractive. One has to bear in mind that it does imply quite a lot of policy power, policy discretion on the part of courts. But finally, that legalistic rights, which are rather different, those which are clearly, they've been worked through by Parliament, they are very, very clearly delineated and resourced with strict criteria attached to them and so on. And I think the evidence, the jury is still out, but on balance, and it is a fine judgment, they do seem likely to do more good than harm in the homelessness field. But this shouldn't be taken for granted. It's not a taken for granted good. It's an empirical question. Do they do more good than harm or more harm than good? And it's an empirical question and needs robust empirical evidence to answer it. Leave it there.
Thank you very much indeed. That was